All right, all right, all right. We're a minute late and a couple of dollars short. It's not our fault. We logged on as we usually do about 5 minutes to, and I couldn't hear Mike. And Mike was thinking, well, that's good, and maybe I can say something without you interrupting me every 5 seconds. So we had to reboot our machines, and the gods of Apple and Microsoft and all those other things that float in the ether control our lives in ways we don't know. Took a moment to make the electronic signals connect. But here we are. Here's a name for you. Craig DeLue Robertson. Do you know who that is? Well, you will soon. Craig DeLue Robertson was shot to death yesterday by the FBI in Provo, Utah, as they apparently were serving an arrest warrant and potentially were there to, as lawyers say, execute a search warrant as opposed to executing the guy whose property
I was having
they were searching.
I was having trouble even putting the banner here together. And I'm like, I can't use the word execute, can I?
Yeah. So, it's hard to know what happened there. And my fear, I don't know if it's fear. My suspicion is that the Robertson name is going to come to loom large in the next 12 to 18 months, in much the way that Randy Weaver out at Ruby Ridge's name loomed large, or in much the way that David Korish's name at Waco loomed large, or the fellows at the Bundy Ranch loomed large. And why is that? We're right on the line of what is and isn't prohibited speech, hate speech, threatening speech. 74 or 75, depending on which article you read, recently retired, elderly guy in somewhat frail health. He was a custom woodworker by avocation, and he was seen, tootling around the neighborhood with a walking stick he made. He owned about 20 guns, which I gather, according to press accounts and the reports of neighbors, isn't unusual in his neighborhood. But he also had strong opinions, even violent opinions. And so he had written on social media about it being time for assassinations, Joe first and then Kamala. Biden was scheduled to visit Utah yesterday and did visit Utah, and he'd posted social media accounts that sounded threatening, or sounded like threats against the safety of the president. So FBI agents got a search warrant, went to his home, not crack of dawn, but 6:15 in the morning, and Robertson ended up dead. Question: was the shooting necessary? Was there really probable cause for an arrest warrant? We talked a few weeks ago, I think it was now, about the recent decision in Colorado, and I'm drawing a blank on the lead plaintiff's name, out of the Counterman decision in the United States Supreme Court about how to evaluate true threats. And this is a direct application of Counterman. The First Amendment prohibits speech, even violent speech, even vile speech, but it prohibits true threats. Well, what's a true threat? A threat is something that is a promise or a threat of violence. And I know that's tautological to use the term in the very definition you're giving of another term. So it's an utterance that could lead a reasonable person. It's an utterance that the speaker must know would lead the hearer to believe that they were under immediate apprehension of harm. I suppose that's it. And I realize that sounds like a lot. But it's about as quick as you can state it. And let me restate it again. A true threat is an utterance the speaker should know carries with it a substantial likelihood that the hearer will be in apprehension or fear for their safety. So here's what, among the things Robertson's Facebook page said. In my dream, I see Joe Biden's body in a dark corner of a DC garage with his head severed, lying in a huge puddle of blood. Hurrah. Okay. Again, am I inviting Robertson over to engage in a little Grey Poupon diplomacy and a discussion about the niceties of political speech? No. He then writes, perhaps Utah will become famous this week as the place a sniper took out Biden the Marxist. The FBI looks at this and they say, okay, we've been out to his house before. They were out to his house in March earlier this year in response to other communications. He told them, get out, basically come back with a warrant. And then he posted on social media, do these agents realize how close they came to eradication? Come with a warrant next time, this, that, and the other thing. So the FBI enters his home, or they appear at his home. And they have a warrant. A warrant is a document required by the Fourth Amendment to enter a person's home or to arrest them. And it must describe with particularity the crime that the person is alleged to have commit, and it must describe with particularity the area to be searched. That description, the crime and the area, it usually comes in the form of an affidavit signed under oath by a law enforcement officer, reviewed by a prosecutor, and then given to a judge for his or her signature. Officers had that, so the press reports. I have my doubts about whether the utterances that I've seen constitute true threats within the meaning of the law. Even though I believe that the utterances are vile. They have the warrant, so they have a right to enter his home. They seek to enter, and he ends up shot dead. The only narrative that can support his death is that he violently resisted or showed signs that he would violently resist the FBI. In our toxic, highly polarized times, it wouldn't surprise me within hours of today or tomorrow to see a whole counter narrative developed, that the man posed no threat, that the utterances, even if they were his, didn't reflect his state of mind when the officers
already got
entered.
some of those counter narratives. I think he was 75 years old. It's already being reported that he was in excess of 300 pounds, that he required a cane to even walk. And so I think that the groundwork for the counter narrative has long been laid. As soon as this was going on, this came to my attention by a random account on Twitter, or X rather. Sorry, Elon. That I'd never come across before, and it seemed as though it appeared to be someone it looked like an anonymous account first and foremost. So make of that what you will. But this account was tweeting in thread form, or posting. Sorry, Elon. And it seemed as though there had been gunshots, or that people in that neighborhood heard gunshots. And then, a couple of hours after it, word got out that this gentleman had been killed. They didn't know the circumstances. And then we're characterizing this guy as just I don't want to call him a delight to the neighborhood, but he wasn't who he appears to be on these social media posts in his local community. In other words, the people in this neighborhood knew who he was. They trusted him. He was not cordial. He didn't pose a threat to anyone.
Well,
right?
maybe
The knowledge that there was a search warrant executed by some sort of law enforcement organization that resulted in his death was far beyond the pale for them.
Well, and it could be that one of the stories that develops from this is, however emphatic his opinions, assuming they were his opinions, they're opinions that are shared by a lot of people. And so, hey, maybe, we're overdue for an assassination. When's somebody going to take the trash out? When are we going to get rid of Biden, Harris? A lot of people may be muttering that stuff. And a lot of them may be doddering old guys wandering around the neighborhood with a cane. That doesn't mean they sacrifice the safety and security of their home. And the king's agents don't get the right to burst through your door because you've said uncivil things about the king. That would be the overblown definition of treason in early modern England. And it's one of the reasons why the United States Constitution explicitly defines treason as an act of violence against the state that requires 2 or more witnesses to be prosecuted. So, there will be a full-blown investigation of the Robertson death. His estate, I don't know anything about the man. Nothing in the story suggests he was living with anyone. There will be an estate open for him, and his estate may very well seek to bring an action arising out of 42 United States Code Section 1983, claiming that the officers were state actors, in other words, government actors, who used unreasonable force in killing the man. And I can see the defense, before I read a document, and the defense will be that they had apprehensions about his intentions based on his behavior and his comments earlier. They arrived and he either reached for a gun or engaged in a furtive movement. That is a movement that led them to believe he was reaching for a gun, and they shot him in the name of their own safety. But I think the thing I really want to know, and I want to drill down on, and will in the days to come is just what the line is that distinguishes mere abstract calls for violence at some future date, or even the wish that a political adversary were dead. What distinguishes that line, which is prohibited, or permitted rather, under the Constitution, from prohibited speech? What made this cross the line such that the government was authorized not just to arrest the man, but to search his home? This will be a direct application of the Counterman test, which we talked about several weeks ago, as I said, and I told you was largely unworkable. And it may well have cost Mr. Robertson his life.
It's sad.
Yeah, sad. And a related case, as crazy as it sounds, is the Andy Ngo civil prosecution of Antifa members. That case ended, I believe, yesterday or late the day before, in a verdict in favor of two Antifa members that Ngo had sued, basically for civil assault and harassment and so forth. Andy Ngo, as you may know, is a journalist, self-described journalist, self-employed, I believe, journalist, who did a lot of work outing members of Antifa in the Portland area. Antifa, as you know, is a loose collection of individuals going back decades who believe their role is to counter what they perceive to be fascism, and if necessary, with violence. And they do so, among other ways, by outing or doxing people who they believe are right-wing propagandists, but they do so under cloak of secrecy. Typically, they'll wear a black hat, a black outfit, and they will organize their events in private and then disappear into the woodwork when law enforcement arrives. This dark force is the people, the will of the people opposing fascism, and they blend into their surroundings when law enforcement arrives. Well, Ngo wanted to out him. And he did. And he wrote a book about it. He attended rallies. And one day he tried to blend in at a rally in Portland, and he was recognized. And two of the defendants in this case showed his identity. He was roughed up and beat up, and he sued. And the result is he also left the country to work elsewhere, claiming it was unsafe for him to live in Portland. He sued 5 people, apparently. 2 of them appeared at trial. 3 got a default judgment.
I'm really interested in that part, Norm. Thank you for bringing that up. But keep going.
So he sued 3, and a jury, and the lawyer for the defendants basically argued he had it coming, that he brought this on himself.
Sort of an unclean hands argument, right?
Yeah, yes, and that's great. So the unclean hands is so thank you for bringing that up, Mike. Unclean hands is an equitable argument. What does that mean? In the history of an Anglo-American jurisprudence, there used to be two sorts of courts. Law courts, which decided cases according to established legal doctrines, and then the king's courts, or courts of equity. There was a recognition that sometimes strict application of the rule of law would fail, and as a result, fundamental fairness or justice required equitable remedies. And so in the United States, the courts of law and equity merged in the 1930s, so we don't have separate courts to apply law and equity. One judge is able to hear legal doctrines that arise both in the law courts or old law courts and in equitable courts. And one equitable doctrine, one doctrine of fairness, is that if you want to bring a claim against somebody, you have to have clean hands. You can't complain that the other person is a liar if your pants are on fire, if you've been lying about them. and so while unclean hands is an equitable defense, lawyers are able to argue whatever a judge will let them get away with. And so the lawyer for the 2 defendants, the 2 Antifa defendants, argued that Ngo can't complain about what he got because it's what he gave. And the jury agreed. And raising the possibility that this jury had nullified and demonstrating, if it did, the dark side of nullification, depending on what you think of the Ngo case. Candidly, I like Ngo. I like his efforts to out Antifa. I've always thought if you believe something and say something, own it. I don't appreciate people who participate in public debate behind masks, who go to rallies and hide their identities, or who go online under pseudonyms and attack others and engage in vile, vitriolic speech. I know personally, I have attracted any number of pseudonymous haters, and I always am amused by that. It's like, thank you for the royalty and the space I occupy in your head, but I don't really want it. You can, take your anonymous comments and flush them. So I don't know whether this was nullification or not. Clearly, when juries commit to follow the law, that benefits the community because it creates a set of stable expectations, presumably, at least among those who read the law and know the law and advise clients on what the law permits and prohibits. And that creates stability in a society.
Well, there seems to be some level of gamesmanship that we have not yet unpacked in this case, but that's the reason I said that what you brought up with respect to the entry of defaults or default judgments against 3 of the named defendants. So there were 5 named defendants. The 2 on the screen there showed up for trial. They were found not liable because, again, this was not a criminal court. This was a civil court. And in general, civil liability abides a different standard altogether than criminal liability. We know that. But the 3 that didn't show up are reported to have been more germane to the claims that Ngo brought in the civil case, so that the 2 defendants that were found not liable were already more likely than not, of the 5, the 2 that would likely not face liability. They coincidentally answered the call of the complaint. The other 3 did not, and just were fine to have a default judgment entered. What does that mean for them? Right? Because they're clearly not culpable or liable in the traditional sense, but we do have a situation with you, Norm, where you represented one Alex Jones, and he showed up and still participated in the proceedings, and there was an entry of default judgment against him, right? So how do these 2 things compare and contrast?
So in the Jones case, there was a disciplinary default, because of the alleged failure of him and his organization adequately to respond to the plaintiff's discovery request. In other words, they sued Jones. They wanted information about him. They persuaded the court he didn't give enough, and the court entered judgment against him, saying you cannot you cannot defend on the merits. The only question at trial will be what the extent of damages is that the other side can prove. We've taken an appeal of the Jones case, saying that this was outrageous. I mean, they got a subpoena on him. They wanted him at trial in a default context, just to light the jury up, and then they threatened to have him arrested if he didn't honor the subpoena. So he turned up in court and told people what he thought of the proceedings. He thought it was a kangaroo court, and the judge was a tyrant. The jury didn't appreciate it and awarded, $1.5 or $1 billion in damages. The judge then enhanced it with an award arising out of something called the Unfair Trade Practices Act. The law of liability, there are 2 parts to any civil lawsuit. There's liability and damages. Call it a 2-part play. In order to get to the question of damages, you must prove liability. In the case of the 2 defendants who got a verdict against Ngo, a defense verdict, they will not be responsible for any damages. In the case of the 3 defendants who were defaulted, in the normal course, they were defaulted presumably for not appearing, for not participating in the process. They have forfeited the right to contest liability, and Ngo is entitled to a hearing and damages against them before a jury. Now, the trial judge will have enormous discretion about how that trial takes place. If she's sympathetic to the Antifa defendants, she might let the jury learn that 2 other defendants similarly situated, sued in the same case, were found non-liable. If you're Ngo's lawyer, you fight against that being admitted, because after all, that would set a foundation of 0 as the damages. No liability equals no damages. And so in the Jones case, for example, where the judge clearly had a manifest bias against him, every effort was made to stack the evidentiary deck against him. The Jones judge concluded that damages had been established without defining what that meant, and then gradually, as the trial unfolded, relieved the plaintiffs of any responsibility to prove that Jones did anything. Everything they said they suffered was Jones's fault, and so the size of the verdict was no surprise. Will the judge do the same for Mr. Ngo in this case? Will it be even the same judge? That remains to be seen. And will Ngo even pursue a hearing and damages against the others?
Well, that was going to be my follow-up, because in the case against Jones, there were, in any civil context, any person bringing a claim is looking for one of two things, right? Performance of certain activity in their favor, or to be made whole, to otherwise be made whole monetarily through compensatory damages. And the court has discretion to award expectation damages and certain of those things in the case of contracts and whatever else. But basically, we're talking about a complainant asking the court to compel another party to do something that they're supposed to do, or to otherwise make them whole. My question here with the civil case is, I'm not sure that I totally understand Andy Ngo's premise behind bringing a civil suit against members of an organization that are renowned for being, judgment proof. Is that fair?
I think that's true. And the other thing is he wasn't looking for all that much. According to the press accounts, he wanted like $300,000, which, I'm saying isn't all that much. I don't have it to give today, so stop asking everyone. But I mean, he wasn't looking for millions. He wanted, some emotional distress damages and the cost of relocating. And maybe he wanted to prove a larger point.
That's because an expensive point, but I think that any counsel and look, I understand. I do understand, but I think that ultimately what someone in his position would want for recompense for what's on the screen is criminal prosecution, effective criminal prosecution. Sure,
yeah, but if you can't get that
and stuff like that, right? So yeah, I understand it, but I just understand that in Portland we are in, and I guess maybe that's the concept of jury nullification and sort of this cultural environment of Antifa, and whether the members of the jury that were reported to have been in fear of being doxxed. I've got that on the screen. It says before closing statements, the judge informed the court that the trial's jurors have raised concerns being doxxed and claimed that people have been trying to find out their identities. This is, part and parcel to the Antifa playbook and what we've seen over the last several years. So it's not clear to me that there was ever, perhaps the greatest win here is exposure to these sorts of facts that Andy Ngo is willing to bring out. So although that he's not successful, I put that on the screen, and I didn't want to say that, they found them not liable or whatever, because 60% of the named defendants in the civil suit just decided that they weren't going to honor the subpoena.
The politics of it, Mike, were interesting. I mean, apparently the case was well attended by both supporters of Ngo and Antifa, and they had to be separated and placed in different courtrooms to observe electronic images of the trial. And the jurors, whether they felt the threat of what would happen to them if they returned a verdict in one way or another, is an open question. And then the question of venue, where are you trying a case matters. You try a case against Antifa in Portland, that's like trying a case against Trump in DC. You know what you're going to get in the jury pool. They're going to be people that are either largely sympathetic to, in this case, Antifa, or antipathetic to Trump, or afraid of the consequences among their peers and in their community if they render the wrong vote. And so it was an interesting trial, an unusual result. It certainly knocked me back on my heels. I'm quick to call for nullification when I think the law is against my client. But what happens when the law is for your client, but they're members of the community or a consensus in the community that your client doesn't deserve the law's protection? In that case, nullification can hurt. And you think of the murder of civil rights workers in the South, and Southern jurors nullifying cases in which there was pretty good evidence that they'd been killed by the defendants sitting in the dock, but the jurors just didn't want to have any of it. And I wonder whether that was part of the factor in the Ngo case. What makes it interesting in relation to the FBI killing in Utah yesterday is that the same sort of speech was at issue. One of the arguments from the Antifa's defense counsel was that they used words that just were this side of fighting words, that were protected speech, that while they used vitriolic speech as to Ngo, they were entitled to use it. Clearly the jury agreed with defense counsel. So congratulations to her. Good luck to Ngo pursuing default judgments. And again, whether it's against the organization, which would be a failing proposition, or the individuals, which might not be, is an open question. If you get a judgment against you in a civil case, this is why you don't ignore writs. That judgment lives on for quite some period of time in Connecticut, where I practice primarily, a judgment is open for 20 years, and a person with a judgment against them can be brought back to court periodically for what's called an examination of a judgment debtor. The defendant, or the plaintiff rather, will be able to determine how much money you have and how much of it they can get to satisfy that judgment. So
that's why I brought it up earlier, is that if there's an assessment, that members of Antifa are relatively judgment proof. And when I say that as a practitioner, I mean someone that might not have the financial resources or ownership of property or anything to attach to upon which a judgment may be satisfied in real life, right? There's a difference between receiving a judgment by order of the court and then actually receiving that recompense or being made whole in real life. You have to have something to secure that judgment. In the case of those that didn't even bother showing up, maybe they knew that they were liable. Maybe if they, in a private conversation, like, yeah, but what's the detriment to me? I go ahead and they find me, not liable or whatever, or they enter a judgment against me. It doesn't matter, because what's he going to get? I don't own anything. I don't have anything to sacrifice here. It doesn't matter.
Yeah, it could be. It could be. Hey, well, what does matter is Harry Ruggs, 3 to 10 years. What's the Ruggs story?
Henry Ruggs, if we recall, let me pull up the story here. The Raiders pick out of Alabama several years ago was driving 156 miles per hour with a blood alcohol content of 0.16, crashed into a woman and her dog, ended up killing both of those after the victim's car caught on fire. Ruggs is no longer in the league. He was part of the Las Vegas Raiders, had seemingly had a bright future ahead of him. But I wanted to talk to you about this because we just came off of the story about Jordan Addison, the rookie this year drafted to the Minnesota Vikings, who was pulled over and only, I guess, cited with a speeding ticket for going in excess of 140 miles per hour. Similar situation with Addison, rookie, high draft rookie pick to an organization, buys a very fast vehicle and then very quickly proceeds to do something somewhat reckless. No consequences, in the latter story, but certainly we are right on the heels of clear consequences with Henry Ruggs. And what does the sentencing guidelines say for someone in Ruggs' position who has clearly he's at fault for killing someone? He entered a guilty plea, at fault for killing someone in a reckless fashion. That life can never be brought back. But what does 3 to 10 years for that sort of behavior signal to the broader public?
Well, so on the obviously the difference between the two young men is one was hollering in a forest where there was no one to hear, and the other one crashed into a tree and killed it.
Critical thought. Rumble says, dark tip for the day: if you ever want to murk someone, just get wasted first and rail them into flames.
Yeah. Wow. Good morning, sunshine. I got sunshine on a cloudy day. No, so I don't know about sentencing guidelines in this case, because every state has its own penal code, and so whether Nevada even operates with sentencing guidelines, who knows? But the law is that if you the criminal law in every state says that if you take someone's life without legal justification or excuse, there'll be consequences. And then the law of homicide, that is the wrongful taking of a person's life, grades this phenomena, the wrongful taking of a human life, in terms of your culpability. And so it will range from a capital felony or first-degree murder down to negligent homicide. And then there are a series of manslaughter offenses that are defined more or less similarly in the states, but manslaughter usually involves reckless behavior rather than intentional behavior. Reckless behavior is less culpable than intending to do something and then doing it. Recklessness is generally being aware of a substantial risk but not caring, proceeding anyhow. And the result in this case is someone's death. This, by contrast to negligent behavior, which is less culpable still, and that is not taking ordinary care, the care that is expected of a person in the community. So, 3 to 10 years without knowing Nevada law, is a substantial sentence. According to the press accounts, he'll do at least 3 before he's parole eligible. This is what's called an indeterminate sentence. So he will be taken into custody by the Department of Corrections there, and depending on how well he does in the programs while he's incarcerated, he either will or will not serve a longer period of time. You say, the adequacy of 3 to 10 years. One of the despairs of criminal defense work is that the sentences are largely meaningless. You especially in a death case. The family's loss, its rage, its sorrow, the community's disappointment and fear, these all factor into a sentencing decision, and the court is left in a position, the judge is left in the position of needing to do something to signal that bad behavior has consequences and the community's expectations will be honored. But how much is enough? I mean,
that's why I brought it up, Norm. Henry Ruggs was 24 years old, or he's 24 years old now. He was not. He was, several years younger when this occurred. I would like to think, and this is me sort of trying to figure out how to square this in view of exactly what you're saying, that the life is gone. And there is this, these theories of restorative justice versus, I guess redemptive, or there's another word that's escaping me right now. It's something soft, but rides the same bus to school kind of thing.
Yeah.
And what I believe strongly is that someone in his position with the type of future ahead of him, if you asked him if he could rewind time and not be that reckless and that ridiculously stupid, he would take that in a heartbeat.
He would, but he did it.
Yeah, and he did do it, right? So those are the countervailing principles, right?
So, I can tell you, Mike, that from the Northeast's perspective, like from a Connecticut perspective, on these facts, had he been pled guilty and gone to sentencing, he would have gotten somewhere between 8 and 10 years. So it would have been far more time than Nevada gave. And so I think of the Nevada criminal justice system as lenient by contrast to what passes for justice.
What happens when you've got Vegas, right?
What stays in Vegas, what happens in Vegas stays in Vegas, unless you're going 156.
Or just recedes quicker, right?
In a 35 zone, So a heavy sentence. I mean, newsflash, don't drink and drive. Newsflash, don't drink, drive, and speed and pretend that the public highways are a street race. Bad outcome for Ruggs, but basically a lenient sentence as far as I'm concerned. So, do we want to pop into Jack Smith and Twitter? Or
why not? We've got a moment here. I'll put this on the screen.
So, what's he looking for?
Well, here is from Truth Social. This is what Donald Trump threw up.
No pun intended.
Yesterday, just found out that crooked Joe Biden's DOJ secretly attacked my Twitter account, making it a point not to let me know about this major hit on my civil rights. My political opponent is going crazy trying to infringe on my campaign for president. Nothing like this has ever happened before. Does the event still exist? Did deranged Jack Smith tell the unselects to destroy and delete all evidence? These are dark days in America. And it does raise the question of what exactly is Jack Smith up to? And there's the report that Elon Musk was fined $350,000 for some form of obstructing the execution of this warrant, right? And finally gave access to law enforcement officials in order to turn over this account. But this is something that I've talked about before, I think, with respect to encryption of direct messaging. We talked about methods of voting in streams past. This is months and months ago. In the use of blockchain, with the highest and best use of something like blockchain would ultimately be. This is interesting to me because Donald Trump has not used his Twitter account since he was kicked off. Even after the account itself was restored, as you can see here, Truth is where his communications have exclusively emanated from, right?
Yeah, but here, look at this. I support Trump's legal efforts, perhaps more than I support the man, and understand his role in American political life and respect him as being this sort of great no, every man's voice in the face of the collectivizing impulses of our times. But in this email, he seems that is Mr. Trump, to be himself deranged. Because, at first I can't tell what he's talking about. Just on Biden's DOJ secretly attacked my Twitter account. So, okay, there was a warrant, perhaps, and the DOJ's investigation was independent of the House Select Committee. So making it a point not to let me know about this major hit on my civil rights. There is a warrant process. There are administrative processes to get these items. My political opponent is going crazy trying to infringe on my campaign for president. Nothing like this has ever happened before. Does the First Amendment still exist? Did deranged Jack Smith tell the unselect committee, presumably the House committee, to destroy and delete evidence? By the time Smith was appointed, that committee had been disbanded. So what the hell is he talking about? At some points, Trump just seems to kind of go back on a toot and just start screaming at the world and connecting dots that are connected perhaps only in his mind. Now, it may be that the House Select Committee went after social media accounts, and I'm sure they did. I know they did with respect to the individuals I represented before them, Alex Jones and one or more of his associates at InfoWars. But to suggest that Jack Smith was doing that when Smith wasn't even part of the investigation, or that he had influence on a committee that's now defunct, what up with that? What up with that?
I don't know. And deeper than this, I think I'm really interested in the technical side of this stuff. So if the investigation is such that they're attempting to secure documents and exchanges and communications and identify individuals or other accounts with whom Trump communicated in an effort to prove the balance of the conspiracy charges they've brought against him, it's interesting to try and understand whether once an account has been nuked in the way that Donald Trump's was nuked and brought back, whether there's any information there to glean to begin with. And there's some credible accounts from those on X right now that then Twitter's policy was that if your account was, if you were permanently suspended and then somehow restored, that your draft messages and anything that was sort of out there was gone on your return.
Well, I know there's been some unreported on drama in the Alex Jones case that the plaintiffs, Alex was nuked from various social media accounts, and the plaintiffs sought to get material from these entities about Jones and apparently didn't get what they wanted. And there's been some side threats of litigation that have, again, gone unreported between the plaintiffs' lawyers and these social media entities. So it raises the very point that you address, and I don't know what the answer to it is. So it's something to keep an eye on. Well, I mean, I wonder whether anything in the digital universe ever really disappears. Well, I mean,
That's true. And so is this more of an exercise and a show of force against? Is Donald Trump a proxy, in other words, here?
Yeah, right? Yeah, I don't know.
Because that is an issue, right? We're still sort of in this new world where Twitter/X has come under new ownership of someone who is to the political left, obviously persona non grata, but also the guy that's working on some sort of brain implant as well. So there's a lot here that I'm just interested in. I think I'm drawn mostly to to Twitter's resistance or X's resistance to providing or disclosing these documents, and the pretty large sanction here.
Yeah.
The delay in their doing that, and also the basis for the Justice Department even requesting that stuff to begin with.
And whether they needed a warrant to get it or whether they could do it by way of an administrative subpoena. That's another.
I wonder if they already had it, and that's why they actually were asking for it to begin with. Because remember, we've had all of these Twitter Spaces and all of these reports on how the government had these back ends or these back doors into Twitter. They had personnel stationed here and there prior to Elon's takeover. So my thought is that perhaps there's something there that they know is there that they didn't have a way to get into court or get into evidence other than going through some sort of above board mechanism or procedure.
That would certainly be consistent with what Snowden taught us years ago about the NSA and its broad reach with respect to receipt and storing of telephone or electronic communications. If we've got somebody who's more tech savvy than Mike and me listening, which would be just in my case, just about everyone.
How dare you?
Yeah, here's the question: and I don't know the answer to this. Does digital do digital signals ever really disappear? I mean, if an account is nuked, that may be that people don't have access to the account, but I suspect the account still exists on a server somewhere.
Yeah, I assume that everything that you've done online at any point in your life leaves a fingerprint, and and that is the reason for that is the reason for all sorts of marketing and advertising now for VPNs and private servers. That's the reason for anonymity on public social media spaces, and the attempt to at least put a buffer between people's recognition of who's speaking and the speech that they're encountering. I think the publicly ultimately understands that the Fourth Amendment online is sort of a novelty.
And a luxury that we pretend we can't afford. But
that's right.
All right. Well, listen, folks, we've talked our way through some of your time today. Thanks for sharing it with us. We'll be back tomorrow morning at 8 a.m. Who knows what the world will bring us to consider between now and then, but we are grateful to you for your continued support. Mike, where can folks find us, and what should they do when they do?
First and foremost, thank you in the cloud for the $5 tip on Rumble. Very much appreciated. You always come through. And I think in the cloud is in vain trying to get, I guess, the gold whale over there on Rumble. She got a little bit jealous seeing someone else in there with a gold whale. So whatever it takes to try, use us as a guinea pig, try to get that gold whale. No, but in all seriousness, thank you. And you can find us every day here on X Live, Rumble Video, and YouTube live. And you can also find us on Apple Podcasts, Spotify, Google Play, Overcast, etc., wherever podcasts are found. As I always say, if you're over there, leave us 5 stars and a nice comment, or leave us alone. Norm, look forward to seeing you tomorrow. Had really great attendance and activity in Rumble today. Thank you all for being here. T-Girl, MDMA for PTSD, BTL, Critical Thought in the Cloud, all the usual suspects. So thank you. Always great seeing you.
Be well, folks. We'll talk to you tomorrow.
See you, Norm.